protection can bring a claim, for example, under the ICCPR, if they are signatories. But the second possible claim by the state, also on the principle of diplomatic protection, is that the exercise of jurisdiction and, of course, the subsequent trial was unlawful because there was no jurisdiction based on male captus, male detentus.
But she was not taken from she was not taken from Burgundian territory. She was taken from the territory of a third country.
That does not matter. The principle of male captus, male detentus does not mention the requirement that the male must be directed towards the sovereignty of the abductee state.
Which brings me back to the original question. This is an injury to her.
Of course that is an injury to her, but there can be a separate claim.
And that becomes a domestic question. We're really not concerned with it. You agree, you must agree with that.
Certainly not, Your Excellency.
You're being very difficult, of course.
If we see from the Bennett case, for example, Toscanino case from the United States itself, Ibrahim case from South Africa, Behan case from Zimbabwe, Levinge case from Australia, Hartley case from New Zealand, Rijolis case from France, and the list goes on. All of these cases
I'm sure they can provide almost equally contrary examples.
I doubt that, Your Excellency.
Okay, I'll let them respond when it comes to respond to them. But do you agree that there is no that's what the point they make, consistent customary international law in regard to that? At best, there is a anomalous situation, and therefore, there is no consistent customary international law. The opinio juris, as well as the physical element, may be missing.
This is precisely the point that is relied on by the respondent. That is, the applicant has failed to address before this court why there is so-called consistent state practice and opinio juris, as mentioned under the North Sea Continental Shelf case, as to why male captus bene detentus, which only one big state in the world, that is the United States, practices, represents state practice. And here I have provided a list.
Might is right.
Certainly. Well,
and in the present world, might is white.
Perhaps in terms of political power, but of course, in front of the ICJ, that is Your Excellencies, we are dealing with legality. And here there is a long list of contrary jurisdictions.
Apart from my learned Chief Judge question about might is right, fait accompli, you probably knows about that, you know. Fait accompli, the fait is there. It was there. State practice continues, and maybe not only the United States, but there will be other. So, if there is some at least persistent, you mentioned North Sea Continental Shelf case. I'm not saying the United States is the persistent objector, but it is a powerful country, and there is no complete uniform state practice in that regard. So, if there is no complete uniform state practice, how can there be customary international law?
Perhaps it would be a convenient time for me then to go on to the substance of the trial, if Your Excellencies are of the view that even if the exercise of jurisdiction was lawful. Here there is one main complaint by the respondent, that is the conduct of the trial was unfair because of the assignment of counsel. Here it is submitted that, of course, the respondent accepts that the right to choose one's own counsel or the right to self-representation may not be absolute in all circumstances. But state practice has shown that this is only allowed when the interests of justice so require, or for example, when the defendant cannot afford his own counsel.
But you know, the Colonel Pathorn, he was also assigned counsel. They didn't discriminate between the two persons.
The issue of Colonel Pathorn is irrelevant before Your Excellency for the claim of the respondent.
It's very relevant, highly relevant. Otherwise, we are, I mean, without offending any standing order, we are all going on a blind track. You see, the point remains that if a state affords different treatment to different litigants, whether they be civil or criminal, in this case both criminal, then that would be maybe a source of complaint. But if they afford the same treatment to both persons, how can that be a source of complaint? They assign counsel to the chap who was supposed to be insane, isn't he? But found not to be so. And then they also assign counsel for to this lady, the journalist, Ms. Tbilisi. I mean, the treatment seems to be fairly even-handed. Do you agree it was fairly even-handed?
Not agreed,
Why?
Your Excellency. The issue of treatment...
Just because you don't agree doesn't mean it's not fair.
I will now provide the reasons supporting my disagreement. Even if there was equal treatment, Your Excellency, let us assume Colonel Fathom, for example, was not given any trial at all. Okay, so they give equal treatment to Ms. Tablisi. No trial at all, automatic conviction of 10 years.
That's a poor example because there was a trial. You're imagining things that you're like imagining this non-existent country called Malaysia and all that. That's all. That's only an example. In this case, you must look at realism. You must be realistic. There was a trial. He had counsel who actually advanced a very strong case. The man was found walking about the military compound, muttering to himself. Am I right? And the court, the independence of the court is shown by the fact that it rejected that plea. So there must have been a fair trial there. And it convicted one of its own people. Am I right? Unlike the Supreme Court of Israel, which acquitted the people who went in and kidnapped Adolf Eichmann. So there is a very different. It's very different. And so it's the same principle that was extended to the journalist. I can't find a better example of equality.
Certainly not, Your Excellency. Even if there was...
You also cannot find it.
Certainly, the respondent will respectfully disagree from Your Excellency's analogy. Even if there was equality in treatment, as long as assignment of counsel was not for the interest of justice, and as long as certain acceptable conditions in international law do not apply, then assignment of counsel in itself would render the whole trial unfair.
This assignment of counsel thing, apart from the issues raised by my learned Chief Judge, the assignment of counsel, is that I know you would cite the ICCPR, but as stated in the compromise, neither of the countries or states are the parties to the ICCPR. Is that a customary international law? Again, I keep on coming to the customary international law part. And if not, even if there is no equality between the two trials, you cannot raise the issue about assignment of counsel.
The respondent certainly notes that both parties are not signatories to the ICCPR, and the respondent does not seek to rely on the ICCPR per se. Of course, as Your Excellency has pointed out, the respondents rely on customary international law. And it is well accepted in customary international law that the right to choose one's own counsel can only be limited in certain circumstances. For example, when interests of justice so require. For example, when national security is involved. For example, when classified evidence is used. Here, none of these relevant principles apply.
They all got a fair trial. I mean, the witnesses were called, the breach of the law was proved, and there was a conviction entered. It's a domestic question. We have nothing to do with it.
And they even reduced the conviction to house arrest.
Yeah.
Reducing the conviction, of course,
The sentence, rather. Yeah.
Is a matter of fact before Your Excellency. But here, still...
But isn't that what my learned brother said? Isn't that evidence of bona fides?
Well, the respondent does not deny at all that perhaps this assigned legal counsel did somehow perform his duty.
I think the compromise mentioned vigorously defended.
However, the issue here, Your Excellency...
Didn't get a lawyer from a jurisdiction called, I can't remember, is it the Kuala Lumpur part? then perhaps her liberty might have been at risk. Such a thing never happened.
Hey, Your
There's
Excellency...
nothing in the compromise shows that she didn't have a fair trial, is there?
There are numerous cases to suggest that even that the assignment of legal counsel per se can render the whole trial unfair, and whether this counsel had discharged his or her duty vigorously.
You're going outside the pleaded case. You're going outside your stated case. That's not part of the stated case. Please confine yourself to the fact. My learned brother has pointed out